Good morning. 2023 P0815 Samuel Smith versus McKesson Medical Surgical Inc. and others is being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, Mr. Cunning. Good morning, everybody. This is our first case on the list that we're conducting by the video platform Zoom. My name is Amy Blake. I am joined today by Justice Eric Nyman and Justice Peter Sachs. We are the panel for the 6 cases that we'll be hearing today, although this first one will be on Zoom only. As we talked about before we went live, Mr. Smith, you are the appellant. So as soon as you see the box with the seal turn to the clock, please feel free to begin your argument. Thank you.
Thank you. Good morning, Justice Blake.
Good morning.
I'm the plaintiff in this case, and I would like to summarize the arguments that Mr. Smith will argue that both the statute of limitations do not apply to the time he was told, and the res judicata does not apply as the case was dismissed without prejudice or supplemental jurisdiction. The dismissal of Mr. Smith's complaint was filed in the U.S. District Court prior to filing his complaint in Suffolk Superior Court. It was not a full adjudication of all Mr. Smith's claims. While in the United States District Court, the defendants moved to dismiss the case in its entirety, and the motion was allowed with respect to the plaintiff's 42 U.S.C. 1983 federal civil rights claim. See Merrimack versus Rennie Medical Labs, Inc. 2019 Mass Supra Lexus 2742, civil number 19 CV11002, which states plaintiff's federal claims for ADEE was dismissed, and the plaintiff's remaining state law claims continued in Boston Superior Court because the court's declining to exercise supplemental jurisdiction over the remaining state law claims that were dismissed without prejudice pursuant to 28 U.S.C. subsection 1367C subsection 3 does not bar the plaintiff from refiling and or addressing the state law claims within the allotted time authorized by this state, which was 30 days, and pursuant to 28 U.S.C. 1367 subsection B. The period for limitations for any claim in the same action that is voluntarily dismissed at the same time as or after dismissal of a claim under Section A shall be told while the claim is pending. See James, which is cited in the plaintiff's brief. The court erred in the dismissal.
Mr. Smith, can I interrupt and ask you a question about the federal statute?
Yes.
What's the time? When McKesson moved to dismiss the complaint in state court based on statute of limitations grounds, did you argue to the state court judge that the time had been told under this federal statute that says, if supplemental jurisdiction is not exercised, then the time is told?
Yes, I did, but I can honestly say I don't believe I worded it the exact way that I worded it just now. But I did say that I filed the brief within the allotted time within the 30 days. And my argument for McKesson is that they never moved to separate themselves from the case while it was in federal court. And had it been overturned and I was granted relief, they would have been brought back in within the United States District Court portion.
Where did you make that argument to the Superior Court judge? I looked through your papers and I didn't see it.
I don't have the transcripts in front of me, but I could forward it to the court. The portion that I believe where I pointed out that the 30 days was, I was allotted the 30 days. Because my argument I kept saying was I did file it at the allotted time. And I didn't really understand the words of res judicata in the statute of limitations. I just knew that I followed the simple guidelines that were reported to me here, that after the decision was made, I had 30 days to file it. And at that time, we had limited time to the law library because that's when we was dealing with the pandemic and we really wasn't able to go to the law library as we are today.
So you're suggesting that maybe if there were a transcript of the Superior Court argument, it would show up there that you had made this argument?
there, yes, it would. It should there, or I can look in my brief, but I know that I did file it in my motions. Because I spoke to several like jailhouse lawyers in here, and they was telling me that I had to file it within the 30 days. If I didn't, I would lose it. Because I thought in the beginning that it was dismissed completely, and they was like, no, only your federal claims was dismissed. You still had state law claims.
What makes me unsure is that the Superior Court judge did not address this issue about the tolling of the statute of limitations when he granted McKesson's motion to dismiss on statute of limitations grounds. So that's why I wasn't sure whether you had raised it.
I was a little concerned with the court's ruling, because in the court's ruling, it doesn't even state the time when the case was dismissed. It only has the U.S. case was dismissed January 9th of 2020. And then it says the U.S. court affirmed the case in 21. And then it says that I didn't file my complaint until 2022, when I actually filed my complaint in 21.
Actually, you filed your Superior Court complaint, I thought, in January of 2022. Is that not accurate?
No, that's not accurate, Your Honor. I filed it in December of 2021.
I have a question about what claims you are actually asserting against the OCCC medical staff in your Superior Court complaint. And I looked at the complaint in the record that we have, and I see two claims which seem to be related. I just want to make sure, are those the only ones, or are there additional ones? This is in your claims for relief. Paragraph 6, you say the inadequate protection at the hands of the medical staff at OCCC and the care they provided fell far below the contemporary standards of decency. And then in paragraph 7, you assert claims under the 8th Amendment and Article 26 of the Massachusetts Constitution for cruel and unusual punishment. Are those the only claims that you asserted against the OCCC medical staff in state court?
I would say that the complaint for medical negligence, failure to notify the adverse side effects and to effectively treat. Because as I'm still going to the hospital for what took place, and I'm unsure if you're able to see on the screen, my entire left side of my face has swollen up beyond the right side.
Where
I still suffer from the fevers. I haven't been treated.
Where in your complaint did you allege medical negligence on the part of the OCCC medical staff?
The part when I was going in front of them, I filed several times to go to see the medical staff and was told while a leg was infected that I should go back to my cell and elevate it. And there's several witnesses that would attest to it, because it was actually the nurses that got me brought to the hospital.
I'm not so much focused on what the facts are that you allege. I'm asking if you alleged a claim of medical negligence against the OCCC defendants and where that is in your complaint, because we need to know what claims are actually at issue in this case, which is an appeal from the dismissal of your claims. We need to know what claims are involved.
I would say it was negligent by not following the referral that was sent to bring me to the dermatologist. By ignoring that referral is what caused the damage. Had I been brought out to see the dermatologist as the referral was made on October 1st, we wouldn't be here today either. The infection would have been discovered.
Did you assert a medical negligence claim in U.S. District Court against the OCCC defendant?
I would say I believe so, because that's what it was allowed in under my interpretation of the ruling, was that they failed to take care of me, even when it was brought to their attention. And I would say it's under number 5. The plaintiff was taken to his appointment on October 1st, 2018. The plaintiff was checked and cleared as of any infection, but there was concern. So Shattuck said,
where are you reading from? You said something about number 5.
It says in number 5 that I was taken to an appointment on October 1st. And that's where the referral was made for a biopsy to be conducted. But there
Number
was no.
Number 5 of what? Is that a paragraph of?
Yes, of the complaint.
Okay, is that the federal complaint?
It's the state complaint that I'm reading from.
So, Mr. Smith, I think Justice Sachs' question was, did you bring state claims to the OCC, the defendants, in the federal action, not the state action?
Under the federal decision, it said I did. It said that all remaining state law claims were dismissed for supplemental jurisdiction.
Right, but the OCCC defendants in their brief state that the only state claims you brought in the federal court were as to McKesson, not as to the OCCC defendants.
I did.
Correct?
I did express that to the federal court as well.
Okay, thank you.
And I would like the court to note that it's missing from the defendant's brief that a status report was actually filed in federal court where they was identifying steps that they had taken, and I notified the court that the steps they wrote were all false. But I was never heard on it. But they were allowed to file a status report because the judge wrote that he was concerned with my care. And I wrote back and said everything they wrote in it was false, and I had the proof to prove that it was false. But it's a lot of things that's missing from their briefs. There's photos that were sent to the court that were not submitted into their briefs, color photos and articles of medical staff that work for WellPath. But it can be noted for the court, these are missing from the brief, and they were filed in the court, but they're not in either defendant's brief.
But you didn't put them in your brief either.
I was allowed a motion because the DOC wouldn't allow me to copy exhibits, and I submitted it to the court, and the court granted me leave. But they left a lot of stuff out of it that was brought to the courts. It's missing.
Can I ask you, when you assert a claim in your state court complaint for care falling below contemporary standards of decency, is that essentially a claim for cruel and unusual punishment?
Yes, I would argue it under the Article 26 because the Article 26 affords Massachusetts residents of greater protection than the 8th Amendment. Article 26 forbids the infliction of cruel and unusual punishment, while the 8th Amendment prescribes cruel and unusual punishment. And I would ask the court to see the difference between the United States Miller case and our Massachusetts Supreme Court case in DeJanko and Maddox, where in each case, our citizens were afforded greater protections under Article 26. It's contemporary decency. And that was.
You have about 2.5 minutes left. Are there other things that you would like to tell us?
In my opinion, if it pleases the court, that the statute of limitations is an affirmative defense. It should have been argued at summary judgment under Rules of Civil Practice 56. In that, at no point did anyone argue that I failed to state a claim. Their argument was just that it wasn't filed in time, and I did have proof that upon further proceeding that I did file it in time and that I did attempt to do everything humanly possible at that time. Because like I said, we were dealing with the pandemic, and I'm under the Department of Corrections rules and guidelines, and the whole medical situation is a catch-22 because the people that I am bringing to court are the people who are in the position to take care of me. And the complaint in the beginning was filed to get medical assistance. It wasn't filed in the beginning for any damages. I had sat for 90 days and was unable to get to court. And it was actually a correctional officer that got me admitted into the hospital. And the hospital said, had I not been admitted, I would have died. So
As I understand this, the legal standard for both the 8th Amendment and Article 26, cruel and unusual punishment, there has to be an allegation that the prison officials have knowledge of the situation of a serious medical need or substantial risk of harm, and they ignore it. Now, I understand that you're saying today that the officials, the OCCC medical officials, did not properly respond. They might not have done everything that you think they could have or should have. But is it fair to say that they actually ignored it?
Abolition definitely ignored it, and there's evidence to prove it. My leg was green, and the correctional officers brought me in medical.
Respectfully, I mean, it seems like your complaint has a lot of allegations about what they did for you. What they did when you came to an appointment. It doesn't say, that's not to say that that was necessarily adequate from your point of view, but they didn't just say go away. They tried to do something.
They did say go away, and each time I got there was a medical emergency from the correctional officers, not medical.
All right, well, we'll have to leave it there, Mr. Smith. Please just put yourself on mute, but don't exit the Zoom hearing. We're now going to hear from Attorney Valding.
Good morning.
Good
May
morning.
it please the court. My name is Laurie Valding, and I represent what I'm going to call the 4 medical defendants: Dr. Strauss, Ms. LaBelle, Ms. Bernard, and Ms. Holmes. So there are 3 points that I would like to make here. The first being that these claims are barred by res judicata. As Mr. Smith pointed out, he filed his federal action complaint in December 2018. He filed amended complaint in May of 2019. That amended complaint has 7 causes of action, and those can be found at page 41 to 42 of the record appendix. So those 7 counts: first one's negligent manufacturing, marketing, and distribution. Second is breach of the implied warranty of merchantability. The third is failure to state side effects. The fourth is a 93A claim against McKesson. The fifth is a 93A claim against a John Doe company in China. The sixth is a failure to label by McKesson, and the 7th is a failure to label against the John Doe company in China. The 4 medical defendants filed a joint motion to dismiss. In Mr. Smith's opposition to that motion to dismiss, specifically at page 62 of the supplemental record appendix, he says his deliberate indifference claim arises out of an incident concerning the absence of care after the Band-Aids were discharged and a failure to follow the Shattuck's recommendations. Again, at page 64 to 65 of the record appendix, he states that he has a claim against all medical staff that they violated his 8th Amendment rights by delaying treatment and failing to provide care. And McKesson filed a separate motion to dismiss. And in their motion to dismiss, they state that claims 1, 2, 3, 4, and 6 are against them, leaving claims 5 and 7 against the John Doe company in China. There were no claims against the medical defendants, and that can be found at page 115. So despite there being no claims, the court, as it must, liberally construe Mr. Smith's complaint, which it did, and found that he did state 42 U.S. 1983 in his amended complaint, and construed his claim as a deliberate indifference claim against the medical defendants. However, there was a failure to state such claim. So they allowed the medical defendants' motion to dismiss. Important on this point is that if you look at the order, specifically on page 69 of the supplemental record appendix, it says the motion to dismiss is allowed. It doesn't say allowed in part. It doesn't say granted in part. It's allowed. And it wasn't a partial motion to dismiss. It was a motion to dismiss the complaint. Had there been state law claims or any other claims against the medical defendants beyond the deliberate indifference claim, it would have said that the motion to dismiss is only allowed in part, which it did not. Mr. Smith then appealed to the First Circuit, and in his statement of proceedings, which is at page 76 of the supplemental record appendix, he says his appeal is based on a civil rights action where he alleges he was denied adequate medical care. First Circuit affirmed that judgment on November 2nd, 2021, and then he filed a state court action in January 2022. The facts in the state court action mimic the facts in the federal court action. The claims for relief, as it was pointed out, against the medical defendants are claims 6 and 7 in the state court action, which is that the care fell below the standards of decency in a violation of Article 26 and the 8th Amendment. The medical defendants again filed a motion to dismiss, this time based on res judicata, and the court allowed that on September 1st, 2022. Mr. Smith now argues in his appellate brief that he's claiming medical negligence, failure to notify, and failure to treat. But claim preclusion bars these claims. Claim preclusion includes claims which were brought or could have been brought. The claims that were brought were ruled upon. These claims, to the extent that they were not there were no state law claims against the medical defendants. And we know that because Mr. Smith said so in his opposition. Mr. Smith said so in his appeal. McKesson said so in their motion to dismiss, and the federal court also said so in the order by allowing the motion to dismiss in its entirety. It was a motion to dismiss the complaint. It wasn't a partial motion.
Where did Mr. Smith say that he had no state claims against the OCCC defendants in federal court?
So he doesn't specifically say he has no state law claims. What he says is at page 62. So in the supplemental record appendix on page 62, that's his opposition to the motion to dismiss. He says his deliberate indifference claim arises out of an incident concerning the absence of care. And then again on page 64 to 65, he states he has a claim against all medical staff that they violated his 8th Amendment rights. And then on page 76 of the supplemental record appendix, which is the his appeal to the First Circuit, it's his statement of proceedings. It says this is a civil rights action where he alleges he was denied adequate medical care. And then my
last page was 70, what, I'm sorry? That's his First Circuit appeal?
76.
76, okay, thank you.
But beyond that, the claims in the state court case arise from the same set of facts. It's September 2018 to December 2018. Those are the facts we're talking about here. And there's 2 cases on point with regard to that position. And that's the Mass School of Law versus ABA case, where the Mass School of Law brought antitrust claims against the ABA in federal court. That was dismissed, and then they redressed them as state court claims in state court. And again, it was dismissed, and the court said, you cannot do that. You just can't claim a different legal theory based on the same set of facts. Likewise, in the Hayden versus McKeon case, the plaintiff brought claims against his surgeon related to a knee operation. In the first complaint, it was negligence and negligent infliction of emotional distress. And then the second complaint, it was fraud and breach of fiduciary duty. Again, they said you just can't redress a different legal theory based on the same claims. And that's exactly what is attempting to be done here. And it's really trying to prevent a second bite at the apple. So for those reasons, we think the dismissal should be upheld, but alternatively, the complaint does fail to state any plausible claims against the medical defendants. Mr. Smith concedes that there's no 8th Amendment claim, or he doesn't have an 8th Amendment claim because it was already adjudicated in the federal court action. Article 26 is the state equivalent of the 8th Amendment. And then there's this count for violation of the standards of decency, which is not a viable cause of action. But looking at what Mr. Smith actually says to the 4 defendants, he says Dr. Strauss prescribed bacitracin and Band-Aids. He transferred him to the Shattuck in October 2018, and he filed this false declaration that does not support an Article 26 allegation. Miss LaBelle, he says that she saw Miss Smith with Dr. Strauss and transferred him to the hospital in October. As to Miss Holmes, he says that she ordered a washout of his wound. And then as to Miss Bernard, he says that he told her about fluid that was leaking from his leg. There was a period where she didn't respond, but then she ordered to have Mr. Smith's leg wrapped. These allegations do not support an Article 26 violation, which is barred by res judicata anyways. And then lastly, there is an independent basis to uphold the dismissal, which is the statute of limitations. To the extent that these are personal injury allegations, statute of limitations is 3 years. Mr. Smith knew as of December 2018, as he was claiming from September to December 2018, that he suffered these injuries. Therefore, he had 3 years, which would be December 2021, to file these claims, and it's beyond that period. I don't want to encroach on what I believe Attorney Merrick is going to discuss with the tolling argument, but I don't think any tolling argument would apply to the medical defendants because there were no state law claims in the federal court. So for these reasons, we believe that the dismissal should be upheld. Thank you.
Thank you. If you could put yourself on mute. Attorney Merrick, you have the last 5 minutes.
Thank you, Your Honor. I'm John Myrick, and I appear today for McKesson Medical Surgery. I'm going to speak briefly on the tolling argument, but then I want to address the failure to state a claim. As to the tolling argument, Justice Sachs asked whether it was made in the Superior Court. I do not believe it was. What the documents show is that the judgment came down, or the decision came down from the First Circuit on November 2. The complaint was filed in January. In fairness to Mr. Smith, he may have had trouble getting it filed on time, but the complaint itself is dated December 21. So that's more than 30 days later. And he simply, to the extent that tolling is an argument, I think that disposes of the argument. More importantly, I'd like to argue on the failure to state a claim. This is an argument that we made for McKesson first in the federal court. The judge didn't address it then. We repeated almost exactly the same argument in the Superior Court, and the judge didn't address it then. But Mr. Smith was certainly on notice that he was told that he had failed to state a claim. And in his federal court pleadings, cited to the cases that are on point, Bell Atlantic and Ashcroft, he knows he has to do more than simply give labels, conclusions, and recitations of elements. He knows he has to give some factual content with facial plausibility. And his filings in the federal court show he was aware of this. That appears in the appendix with actually those two case citations at page 125, which is one of his filings in the federal court. If you look at what his substantive claims are against McKesson, he's claiming negligence in manufacturing, marketing, or distribution, but he makes no factual statement. He simply gives the label, and he doesn't even go into much of a recitation of the elements. He then says, well, there's a breach of an implied warranty. Well, to succeed on a breach of implied warranty, he has to allege facts that the Band-Aid was broadly unsuitable and not fit for ordinary purposes. What he actually shows in his allegations is that he is susceptible to the adhesive that was on that Band-Aid. This case arose from a puncture wound in his leg. The puncture wound was less than 1 millimeter in diameter.
Not a question of fact, though, Attorney Meyer. Isn't that a question of fact? Whether he's got a particular sensitivity to the adhesive, or whether the injuries or adverse effects that he suffered was due to something that's kind of inherent in the bandage. How can we resolve that on a motion to dismiss?
Well, Your Honor, please, there are several cases that I cited in my brief where this has been addressed. And somebody,
cases, if I may, those are pretty old cases.
They are, but I think they're still good law. I don't believe they've been overturned.
Well, they don't seem consistent with modern theories of product liability, at least as I understand.
I disagree with Your Honor, but that's what makes for appellate arguments. Mr. Smith has to show some factual basis to make this plausible, and he doesn't put that in there. He simply says And a key element here is his 93A demand letter. He simply says, I have a patch on my skin that is the shape of the Band-Aid. And I believe he's probably correct that the adhesive from the Band-Aid caused that dermatitis reaction. He has nothing to show that the adhesive from the Band-Aid got into the wound. Indeed, common sense says when you apply a Band-Aid, you put it so it doesn't touch the wound. And he's
Mr.
got.
Myrick, that is your time. Let me check to make sure whether Justice Nyman or Justice Sachs have any additional questions. All right, we're going to have to take the rest of your argument on your brief. I'd like to thank all three of you for very helpful arguments this morning. The case is under advisement and you will get a decision from us shortly. Thank you.
Thank you.
Thank you.
We are going to head to the courtroom now.